So thank you all so much for joining me today. My name is Emily Kile. I know everybody is busy, so I really appreciate those of you who are able to attend live with me today. And as I said, if you have questions, you're all muted, but go ahead and type into either the chat box or the Q&A, and I'll try and keep my eye on both of those throughout the presentation if you have any questions at all. So with that, I'm going to go ahead and get started. So as I said, these are the two topics we're going to cover, and we have a couple of different kinds of special needs trusts, so we'll spend a little bit of time on that. And then we're going to talk about ABLE accounts as well. So sometimes attorneys call special needs trusts SNTs. So if you hear that, that's just us with our acronyms, and I'm sure all of you in your own fields of practice have all kinds of acronyms for things as well. Sometimes it's called a supplemental care trust. Sometimes it's called a supplemental needs trust. Sometimes it's called something completely different than that. And the name of the trust is completely irrelevant. What we care about are what do the terms of the trust say, because those are the rules. The trust is kind of the rule book for what we do. And so again, the name of it is not very helpful. The all-text manual calls them special treatment trusts because they get special treatment. So the reason that we do these kinds of special trusts are to shield money that's more than $2,000 for a person who is on benefits such as SSI or all-text, or would be eligible, but for the fact that they have funds that exceed that $2,000 limit. And remember that $2,000 limit includes, where you're depositing the Social Security funds. If the person is working and they have their own checking account, that account, those bonds, those U.S. savings bonds that maybe a grandparent provided when the child was first born. We have to add up all of those assets that are not in an ABLE account and not in a special needs trust, but are only in the name of the beneficiary to determine eligibility, because that all stuff gets added together. It's not like they can have $1,500 in a whole bunch of different separate accounts. So the other thing about special needs trusts is that even though the attorney or the person you use to draft the trust may think it was absolutely perfect, it always has to be reported to the agencies that provide services as soon as there's one penny titled to the trust, because those agencies provide services, they have a right to review it and make sure they agree that it meets all of the requirements. And of course, the hope is that the funds that are in that trust will be used for improving the quality of life for the beneficiary, because $2,000 doesn't go very far. And so the money is there to help offset those expenses. Sometimes I see special needs trusts that say that you cannot use the money to pay for food and shelter items, and that I don't think is appropriate. The special needs trust can pay for food and shelter. The idea, though, is that that may reduce the amount of SSI that beneficiary gets if they're receiving SSI. If they're receiving Social Security disability benefits, those benefits wouldn't require a special needs trust because those aren't sensitive to how much money the person has in the bank outside of a special needs trust. So typically the SSI from the government's perspective is meant to cover all of the food and shelter expenses. I don't know where they live that they think $785 is going to cover somebody's rent and all of their food costs, but that's what they say. So when somebody else pays for those food and shelter expenses, the government says, well, then you don't need all of the SSI because you have some other source that's paying for those costs. And so the SSI is reduced by about $250. It's a calculation that Social Security makes, which is 1/3 of the maximum $785 minus plus $20. So it's about $250 that they get a reduction if they're living at home with you and you pay all of their food and shelter costs, or the money's coming from a special needs trust, or a grandparent is paying, or they don't live with you, but you pay for those costs. And so that needs to be reported again so Social Security can determine how much SSI needs to be paid. So when you do your interview, they may ask you, is this beneficiary going to cover all of their own food and housing costs? And so you just want to be honest about it. We don't want anybody to end up with an overpayment and have to pay funds back. We don't want to end up with any fraud. So just make sure you're being honest when you do your interview, or if things change, just send written notice, send it certified mail so you get the little green card back to show that you let them know that there was a change in circumstances. One of the hallmarks of a special needs trust is that the trustee, that is the one who manages the money, has complete discretion about the distributions. So if the trust says that the funds will be paid out at 10% a year, or when a child turns 25, they're going to get half of the funds and the other half at age 30, that is not a special needs trust. I don't care what it's called, it's not a special needs trust. It's not going to shield the funds that are in that trust from being counted against that $2,000 limit when the beneficiary reaches those ages. So sometimes a grandparent or somebody will have drafted the trust that way, not knowing that we might have a beneficiary who needed some assistance from these government benefit programs. And sometimes we can fix those trusts. So if they were supposed to get money when they were 25 and they're not 25 yet, oftentimes we can fix those trusts, even if the trust says it's irrevocable, so that we can put in this discretionary standard and still ensure that the person can retain their all-tax benefits, DDD benefits, and SSI benefits. The beneficiary can be as angry as they want and kick and scream all they want and demand the money, but the trustee is the absolute gatekeeper. I saw a presentation or co-presented with a person not that long ago, and what they had on their slide was a little police officer with his hand up. So that's what the trustee is. They're the ones who are the gatekeeper between the beneficiary and the beneficiary's money. So no automatic payments to come from the beneficiary. So there's definitely a loss of control. We're going to talk about the ABLE account, which could give the beneficiary a lot more control. But money in the special needs trust is 100% not in the control of the named beneficiary. And that is true whether we're going to talk about two different kinds of special needs trusts. So it doesn't matter whether it was part of your estate planning or the person ended up with a personal injury attorney, or a person, grandparent died and left money outright to a beneficiary on services. These 3 points are the same between the two different kinds of trusts. So let's talk a little bit about what those two different trusts look like. I know this is really confusing, and I wish with all the words we have in the English language that we came up with different things to call them. Again, it might be called a special needs trust, a supplemental needs trust, a supplemental care trust, a special treatment trust, whatever it's called. We have two different categories of where the money comes from that determines the flexibility and what the requirements of the trust might be. So we have something that we call first party special needs trusts. Again, whatever the name of the trust is irrelevant. This is a trust where the money that went into the trust was the money of the beneficiary. So if you put the excess Social Security money into a special needs trust, that's a first party special needs trust, because the Social Security is the money of the beneficiary. So I have a niece, Marissa, who has Down syndrome. If I pass away and I left her an outright distribution, it just said when Emily dies, $100,000 to Marissa, and then that money goes into a special needs trust so that she can retain her all-tax benefits, her SSI, and her DDD services. Those funds would go into a first party special needs trust because I didn't skip over her directly into the trust. I just said she was going to get the money directly. So those are what we typically call a first party special needs trust. This also happens when we have money from a personal injury settlement. So maybe a person is crossing the street, they get hit by a car, it goes to court, that person ends up with $1 million and they are in need of all tax benefits and SSI or just all tax benefits. those funds would go into a first party special needs trust, even though we might have a court order that says they're going to go into a trust. They're the money of the beneficiary, the injured party. The biggest hallmark, well, there's a couple, but one of the biggest hallmarks of a first party special needs trust, this is where we get into that payback language, the language that people get concerned about, which is that when the beneficiary passes away, then the funds that are in the trust can go back to the states that provided Medicaid services. So if Medicaid or Alltex provided $10 million worth of services to this person and there's $3 left in the trust, then the state is going to get that $3. They don't come after anybody else. They don't have a right to sue anybody else for those funds. But if a $10 million of services were provided and there's $11 million in the trust, the state's going to get 10, and then the beneficiaries, the heirs of the deceased beneficiary, are going to get that other $1 million. And so whether you know it or not, Alltex is keeping track of their daily rate, which honestly may have nothing to do with the total actual expense that's being provided. It may just be that daily rate when somebody's on benefits and living outside of the home, on benefits and living in the home. And you can contact HMS, which is the collection agency, anytime and find out if that's true. They're not supposed to have any lien rights outside of a special needs trust if the beneficiary is under age 55. That's when they're supposed to start counting and figuring out if there would be recovery. But because the beneficiary can't ever have more than $2,000, it's usually an irrelevant issue. But in these kinds of trusts, it's a very relevant issue, and that payback starts at the date, or the calculation starts the date that the trust was funded. That is the date that money went into it. So even if it's a 3-year-old child and then they pass away, the state will still have a right against the funds that are remaining in the trust. Once the beneficiary passes away, you can't take any money out of these kinds of trusts. We're going to talk about the kind of trust you do as part of your estate plan in a minute. Not this kind where it's the beneficiary's money. And so if you've moved between states, all the states' rights get protected. So the trust would say whatever Medicaid agency was providing services, the funds are going to be then reimbursed on a pro rata basis to those various Medicaid agencies. So you don't get out of it if you move from one state to another to still have that payback requirement. So then we have our third-party special needs trusts. So these are trusts where I have my niece who has Down syndrome. I draft my estate planning documents, and it says it goes in equal shares to my nieces and nephews, but the share for Marissa goes into the Marissa Special Needs Trust. So when I pass away, the nieces and nephews are each going to get their share, but the share for Marissa is going to go into her own special needs trust. Those kind of trusts do not have any kind of a payback requirement. I can say who the beneficiary is. I can leave it to charity. I can say if she passes away, it goes to her siblings. I can say it goes to my neighbor, whatever I want to do. There's no payback to the state. State Medicaid agencies have no right to any funds that are in the third-party special needs trust that I've drafted as part of my estate plan. And you can also have a third-party special needs trust that is for a whole bunch of people to put money in. So for Marissa, I drafted one for my mom to sign, so she's the trustor. Then my estate plan says it goes into that same trust. My brother and sister-in-law say if money goes to her, then it goes into that trust. With a first-party special needs trust, we need a separate one for each disabled beneficiary. For these third-party special needs trusts, we can have one trust that's a pot trust, for lack of a better description. It can have lots of different beneficiaries and lots of different people can contribute to it. If 1 penny of the beneficiary's money goes into what was a third-party special needs trust, it's now become the other kind, and now it will have to be amended to include that payback requirement. So it's really important as part of your estate plan that your trustee understands that they cannot put, in this case, Marissa's money into the special needs trust that I've put my own money in. So they're not going to put her excess Social Security in to keep her below the $2,000 limit in that trust. They're not going to put any personal injury award money into that trust. The third party special needs trust, again, I can contribute, grandma can contribute, aunt and uncle can contribute, parents can contribute, but the person who's the beneficiary of the trust, their money cannot go into that trust. And for both the first and the third party, remember the money is there to take care of that beneficiary. It's not like it goes in the trust and then can't be used for anything. Its whole job is to make sure that those funds are used for the benefit of that disabled person. So the special needs trust that's part of your estate plan can be done in a whole variety of ways. So it can be in your will. It can be part of your own last will and testament where you say, if, you know, the share that goes to Marissa, these are all the special needs trust terms. We don't have to draft another trust when you die because the terms are already in your will. It can be a separate trust document, which is what my recommendation is. And I'll tell you why in just a moment. So we can have the, you know, Marissa has her own trust document, just like you have your own trust document, your own will. There would be one that is the Marissa Special Needs Trust. It can also be a subtrust if you have a trust. So you can say, you know, the share for Joe, he gets outright, no problem. The share for Mary, she gets outright. But the share for Marissa goes into, and then you have all the terms. And again, we don't have to draft a new trust at the time that you pass away. We've already got all of the terms of the trust set forth within the document. So the reason why I like a separate trust document is because we have to report that trust, as I said, to the agencies. And by what I mean by that is a copy of the trust document, an explanation of where the money came from, and copies of all of the bank statements or other statements that show what the, you know, the Chase bank account that has the Marissa Special Needs Trust showing as the owner of that. If it owns real estate, we have to provide the deeds. If it owns investments, we have to provide a copy of the investment statement. So all of the assets that are part of that special needs trust need to go to the agencies that are providing benefits, whether that's SNAP for food assistance, to the housing authority if the person's in subsidized housing, to Altex if they're getting DDD and Altex benefits, to Social Security if they're on SSI. So whatever government benefits they're receiving. And typically the easiest thing to do is to draft the letter and copy all of the agencies on that letter. Always send it certified mail to get your green card back so you can show that you sent it. If it takes them forever to review it, you are not defrauded anybody. You told everybody from the beginning. You do not have to report the trusts, either one, when there's no money in them. They're only reported when it has money. So during my lifetime, during my mother's lifetime, during Marissa's parents' lifetime, there's no money in that trust. It will only get money if and when somebody dies and she becomes a beneficiary, or the trust becomes a beneficiary. So it doesn't have to be reported to anybody before them, but it's really important that you do send it in. The best news you get is no news. So when you send it in and you never hear from any agency, you are fine. Sometimes, however, Social Security can take years to get around to deciding it's time to review the trust, and then they may send a letter saying, we have an issue with whatever, and we don't think that this meets the requirements for a special needs trust, and it's a counted resource, and you owe $1 billion in back pay because you were never eligible. And you go, oh my gosh, what has happened here? And it's a terrible moment. It's very frightening. They are often incorrect, but you only have 10 days to make a request for reconsideration. So don't delay, don't procrastinate, don't stick it at the bottom of the pile because it's freaking you out. You want to absolutely make sure that you write back to them and request a reconsideration, because during that time period, then the benefits stay in place until a decision is made. Well, you might go through a reconsideration, then you might have to have a second reconsideration. You might actually have to go to the administrative proceedings and file an appeal. And that can take, let's see, I've done one of those. It took 2 years from the time that I made my request for a reconsideration, which was denied, to get it to the appeal stage in front of the administrative law judge. And throughout that time, the beneficiary kept their benefits. I went to the hearing. I got a decision that was favorable, saying, yep, the trust is fine. Everything stayed in place, as frightening as that was for everybody. So just don't put your head in the sand. It's a very arduous process, but you have to go through it, because if they say that the person wasn't eligible, then they may request that they pay back the benefits that were received, whether that's because you had $2,001 outside of the trust or the trust didn't meet the requirements. So be very cautious about that. I want to go back to talking about the first party special needs trust in a couple of areas that relate to Altex and DDD. And these, again, these are those payback trusts, the trusts that have money from the beneficiary. So for those trusts, you're also required to provide what are called an anticipated disbursements, and sign a document that's the rights and responsibilities of the trustee, if in fact you are the trustee. So the anticipated disbursement form is the budget for the year. So those kinds of trusts under Arizona law, we have a statute that says what you can and can't use the money for. So while it encompasses pretty much everything you would want to use the money for, like buying a new cell phone, getting a bed, buying some clothing, having a tutor, going on vacation, that beneficiary paying their share to get into Disneyland. They need eyeglasses. They want a haircut. Like pretty much anything you can think of is probably going to fall within the categories that are allowable for the first party special needs trusts. But you do have to complete a budget that gets submitted to Altex that outlines for the year how you're going to use those monies. It can be updated at any time. They do have 45 days to review those anticipated disbursements. Typically, you don't hear anything, so you wait your 45 days after you did your reporting, and then you can start to use the trust in that way. They may have questions. So you've said that you want your category for entertainment in the month of December is $10,000, and in every other month, it was 300. They will say, well, what's it for? You can say, well, we're going on a trip wherever, and here's a quote for what the airfare is going to be, what the cost for the hotel is going to be, what the cost for entrance into the museums and the parks are going to be. And that's how we came up in that month for that particular category. If the special needs trust has a lien against a vehicle, so you need a specially equipped vehicle that was purchased with money from the trust will hold the note or the lien against that vehicle. And then the trust can certainly pay for all the transportation expenses associated with the car, whether that's gas, insurance, repairs, maintenance. So all of that would go on that anticipated disbursements. Even if Altex doesn't ask for it, you must submit it, and you should do that every single year. And I recommend that you provide an accounting to Altex, and if they're on SSI, to Social Security, as to how the funds were used, because they have a right to the money when the beneficiary dies, and you may have used it all up, and then you would report that. It's so much easier to just do the accounting every year. And then when they ask for it, you have all of the years and you have all of the bank statements and everything to support why it is that there's only $2 left in that trust. So be very conscientious on your record keeping when you're dealing with special needs trusts. For the third party special needs trust, it may be that the remainder beneficiaries have a right to accountings. So maybe it's money held in trust for your disabled daughter, but you have a son, but the son would only get the money if your disabled daughter passed away in your estate planning third party special needs trust. So it's probable that your son is entitled to accountings, which is really helpful because then we have somebody overseeing the trustee to make sure the funds are being used correctly. And it keeps that son apprised of, oh my gosh, my sister's running out of money. I probably need to talk to the trustee or somebody about what we're going to do so that we don't end up with not enough funds and my sister's still alive. So it can be really helpful. If the remainder beneficiaries are fairly unpleasant, it is less helpful, because then they may be saying, hey, you're spending the money and you need to save it for me, which is not true. So that may become more problematic. So that's how those trusts work. Those are things that are really important to remember when you're working with special needs trusts. And I'm going to move on to ABLE account and the ABLE Act. I don't see any questions or anything in the chat box, so I'll presume there are no questions related to special needs trust. If you change your mind and you think of something, by all means, just type it in there and I will do my best to answer your questions. So we call them ABLE accounts or stable accounts. They were called stable accounts in Ohio, which was the first state to get up and running with these kinds of accounts. And then they helped our Arizona Department of Economic Security to get them up and running in Arizona. And so they're often referred to as stable accounts here in Arizona as well, which is basically the state ABLE account. So if you go to the website, this is the first screen that you'll see when you get there. The website is, I have here, www.az-able.com. That is where you want to go in order to open these kinds of accounts. Over here, they have something called FAQs, frequently asked questions. They're excellent. I would definitely recommend, if you're not sure whether you need one or you have one and you have questions or you just want to learn more, I would definitely go to the website and click on the frequently asked questions section. Because as I said, I think they're great answers, very helpful information about how to open the account, what can you use the money for, how does it work, what are the costs, what are the investment options. So super helpful. I'm going to try and walk through some of those issues with you, but I would recommend that you go there. So somebody's asked whether we have handouts. We thought we could put my PowerPoint as a PDF into the chat, and so we could share it that way, but apparently it doesn't work that way. But if you email my office, we are happy to email you the PowerPoint as a PDF, and we also have a handout on ABLE accounts that we've put together. And so you can email Sarah at KileLawFirm.com. I will put that right in the chat box. I'm going to type it out here so everybody can see it. So it's Sarah at Kile with an I, K-I-L-E, lawfirm.com. And you can, I'll send that to everybody. And so she is more than happy to provide you with a copy of this PowerPoint as well as our handout on ABLE accounts. So hopefully that's helpful. So in order to be eligible for an ABLE account, the beneficiary has to have been deemed disabled prior to age 26. So if the person had autism diagnosed when they were 12, you're fine. If you think that somebody, your loved one, was disabled but wasn't determined to be disabled prior to age 26, so long as you know maybe you have their IEPs, maybe you have their neuropsych evaluation, you have something to show, so you can basically self-determine and have the physician documentation so that it would be you would be able to back up that in fact they were eligible. If they weren't eligible and there was an audit or whatnot, what happens is because the funds can grow in the account on a tax-free basis and the money comes out on a tax-free basis, you would have an income tax problem. That any growth on it and any distributions would have to be reported to the beneficiary with regard to income tax issues. So the account can be set up in any state where there's legislation. If it's not Arizona, you need to make sure that they allow non-residents to open ABLE accounts in their state. Arizona only allows Arizona residents to open the ABLE account here in Arizona. And again, I would recommend you just use our stable program, az-able.com. It's, the rules are set by the federal government, so there aren't very large differences between the programs. And I think that Arizona has done a really good job to kind of take the best of all of the programs and what's available to use. There can only be one account per beneficiary. So it's not as if maternal grandmother and paternal grandmother can each set up an account, or for divorced parents or unmarried parents that they can each set up an ABLE account for their loved one, because only one account per beneficiary. The annual contribution into the account is set to be the same as the annual gift tax exclusion amount, which this year is $15,000. I have no idea what it will be next year. Typically it goes up. I don't know what will happen, but for this year it's $15,000. The funds can come from anybody. So you can take excess Social Security money if they're getting close to that $2,000 limit and move it into the ABLE account. You can make contributions to the ABLE account. Your sister can make contributions, your neighbor, your parents, whoever wants to. Not more than $15,000 in a calendar year. There's no like catch-up provision where you can be like, oh, I should have done this. I'm gonna, fund it since the time that the person was born if they had a disability that began at birth. It's only $15,000 in a calendar year. If you attempt, or somebody attempts to put more than that in, it will be rejected. So hopefully the system works, and so we don't have overfunded accounts that can lead to problems. And if more than one person opens an ABLE account, only the first one that is opened will be an excluded resource. So if the other person, another person opens an account, that's a counted resource and goes towards the $2,000 limit. So just be aware of that. And like our first party special needs trusts, there is a payback provision. So for when the beneficiary dies, there are actually some exceptions or exemptions that money can come out for, like funeral expenses, which is not the case with a first party special needs trust. You cannot touch that account once the person passes away. But for an ABLE account, there are some exclusions. There's the ability, I believe, to pay administrative expenses and funeral costs. So other than that, though, the state Medicaid programs have a right to recover up to the amount that they've calculated they are entitled to receive back. If the person the person can go up to 100,000 if they're on SSI, and then the SSI will be suspended. It won't be terminated once the account goes down below the $100,000 limit. Then they'll be reinstated for their SSI benefits. The total account, I think, can go in a lifetime up to the same as the 529 college savings limit, which is like $600,000. So if they're not on SSI, it can certainly grow to be pretty large, but again, be conscientious that it does have that payback provision. So if you've set up a third party special needs trust and people want to make gifts, it would be best if they made the gifts to the third party trust rather than to the ABLE account, because then there wouldn't be that same requirement of a payback. Just answer this question. But there are some differences as well between the special needs trusts and ABLE accounts, which we'll get to in just a moment. So I said that there's a $15,000 limit, but there's an additional amount that the beneficiary can put in if they're working, but their employer isn't contributing to a retirement plan. So they're not eligible for the retirement plan. Then they can contribute an additional amount equal to the smaller amount of their gross salary, or $12,880, at least that is for 2021. So they could have, what is that? $27,880 could go in a year if they're working but not able to contribute. So sometimes that happens for beneficiaries who work on a part-time basis, or they work at a place that doesn't have a retirement account. There's no 401k plan available to the employees. And so then there can be additional funds that can go into the ABLE account. So ABLE is really helpful because, as I said, it can be, the money in the ABLE account doesn't count, just like in the special needs trusts. So you can have that 100,000 in there and still have a person who receives SSI and or All-Tax DDD benefits. The funds coming out of the trust don't count as income towards the income limit or as a deduction to SSI, because it's the beneficiary's money and we're just moving it from pile A to pile B, so to speak. And so it doesn't count towards the income limits, which is really nice. Normally, we're not going to provide cash to the beneficiary. The ABLE account, you can get a prepaid debit card, so you can put money on it, and then your beneficiary can get their hair cut, and they can go out to lunch with their friends. They can go grab a coffee, and they just have their card that they swipe that has money on it from the ABLE account. No deduction to SSI for the use of the funds in the ABLE account for food and shelter costs. So they won't have that $250 deduction either. The accounts are free to set up, but I do think even if you hold it all in cash, I think if there's like a $10 annual fee to have them. I could be wrong. It has it on the frequently asked questions, but there's no cost to set them up, and you can open an account with $50. So it's not as if you have to be super wealthy in order to get it opened. And you can send invites directly from the ABLE account if people want to make gifts, so that they know that they can make them into the ABLE account if that's what you want to happen. The ABLE account can only accept cash. You can't put securities in there, stocks or bonds or real estate. Once the money's in the account, then there are some investment options. I believe it's through Vanguard. And so you can choose, I think there's like 6 different risk tolerances, and you can choose what you want and how much of the account you want to be invested. And then, of course, there's a fee that Vanguard charges to manage those assets. The money grows on an income tax-free basis, and the money comes out on an income tax-free basis. So much like a 529 plan, which is just for education costs, the same is true here in the ABLE account, just in terms of the fact that it's you avoid some of that income tax that you would have as a gain if it was in a special needs trust and then came out to the beneficiary or was growing. There's no brick and mortar bank, so you can't, go to your local bank and then say, I'd like to open an ABLE account. They're all opened online through that website that I provided, az-able.com. So the funds are to be used for what the terminology in the statute is qualified disability expenses. But I am telling you, I've never heard of something that is not a qualified disability expense other than making gifts. Don't use the money to give it away to somebody else, but it can be used for education, housing, a bus pass, gas expenses for a vehicle that's owned by the beneficiary. It can be used for a headset, for a phone, for a computer, for a tutor, for dietary supplements, to see a homeopathic doctor, for legal expenses, for anything pretty much under the sun that benefits the beneficiary. But again, we can't give the money away. We don't use this money to make gifts to anybody. I do recommend, as morose as it is, that if you have funds, whether in the special needs trust or available for an ABLE account, that you prepay for funeral or cremation costs. They're going to have to be paid at some point. And it is, first of all, you're paying in today's cost, not the cost in 50 years when your beneficiary passes away. So you get that savings. And it just is one less thing for you to have to worry about later, especially because other than the third-party special needs trust, the one that's part of your estate plan, you can't access the money until you get permission for the most part. And so there could be a delay. And so if you just have that all paid for in advance, one less thing for anybody to worry about, think about. It's just there. The funds are there to take care of that person at the end of life. So these are some of the most important features in terms of what some of the benefits are. You can roll a 529 plan in at $15,000 a year into the ABLE account. You have to think about whether you want to do that. because you may end up having a different beneficiary who could use the 529 plan for education expenses. And so if that's what you're going to do with the money, then that's great. Also, you might want to take it out of the 529 plan if there's going to be, there may be a tax consequence, but maybe you have some other use for those funds. Because my understanding is you own the 529 plan. It just gets used for the benefit of the beneficiary. You can also now, which we couldn't do before, move money from a first party special needs trust into the ABLE account, which is great because we don't have that anticipated disbursements budget issue that we have for Altex on money that's in a first party special needs trust. So that just went into effect this summer. So that's very, very new and is super duper helpful so that there's a little bit more flexibility in the use of the money. And if you're using a professional trustee, the money in the ABLE account you have access to in terms of that prepaid debit card. So again, it has to be used for the beneficiary, but it's not as if you have to get permission from a third party to get the funds out. And if you have a beneficiary who, as I said, is going to go independently, you know, get their hair cut or pick up coffee or go out to lunch or go to the movies, then they can feel more independent because you've loaded the funds onto that card for them to use for that reason. So a question is whether the money in the ABLE account can be used to repay an SSI overpayment debt. I would say yes, that's for the benefit of the beneficiary. However, the question is, do you want to do that? So if you have an overpayment, that is the beneficiary was paid SSI benefits that they were not entitled to because they were over resources or for some other reason, if that person can remain eligible, so they have an overpayment, the money was spent down, they meet the criteria again, Social Security can only deduct the maximum of 10% of the maximum SSI payment, which again, the maximum payment I think is $794. So they would deduct about $74 a month until they got paid back. If the beneficiary doesn't have any money, you might be able to get a hardship waiver. So you would want to figure out, does it make sense to use the money that's there to do the overpayment? And if you're making contributions into that ABLE account, we're probably not going to want to make a contribution if then that's going to be subject to that overpayment requirement. If you have excess money in another account, well then, you know, spend it down, figure out what to do with the rest of the money into a first party special needs trust or an ABLE account to get the person back on benefits, and then ask them to reduce the benefit by that 10% amount so that they would continue to stay eligible, would continue to get their funds. They're just reduced by some smaller amount of money. So remember some of the limitations, unlike in a special needs trust where you can add $10 million, only $15,000 a year into these or whatever the gift tax exclusion amount would be. You're going to have an SSI suspension if it's over 100. We still have that same payback to our the Medicaid offices, just like in a first party special needs trust. And again, one ABLE account per beneficiary. And then the last point, bullet number 5, different commissioners may treat this differently, but my experience has been if there's money in an ABLE account and you then are going to apply for guardianship for your loved one, that is now that is money that is now owned by the beneficiary. So then we can't get a waiver of the filing fee, court investigator fee, and court appointed counsel fees that are all required as part of a guardianship. And those can be expensive. The filing fee and court investigator fee are about $800 in Maricopa County. And your court appointed counsel fees might be $1,500 or $2,000, depending on how much work the court appointed counsel had to do. If there's no money in the ABLE account till after the guardianship, then you won't have to pay those fees. But if there is, the commissioners I've been in front of, we disclose that there are funds in the ABLE account. The person is not indigent, and then those funds are used to pay those expenses. Now, that may be totally worth it because without the ABLE account, you might not get any of the benefits that the person wants and needs. But I do, just to caution you, you want to think about it before you start putting money in the account. So a question has come up about what if ABLE accounts aren't recognized in any state and you move? So if you were a resident of Arizona and you opened your ABLE account here, my understanding is you don't have to change it and move the funds to another ABLE account because you've now moved out of the state. You should be able to just keep the account here. The same as if you moved out of a different state, you should be able to have the account there. If for some reason that isn't what's happening, there are lots of states that allow non-residents, like Ohio, to be in their ABLE plan. So the money would get rolled over into the new ABLE account in the state that you need it to be in. If, again, your state doesn't have it, you would just go to a different state that allows for non-residents to open an ABLE account there. So hopefully that's helpful to that question. If not, just send me another one. So these are the ways in which we've most commonly, or I've most commonly counseled people on using them: small personal injury or an inheritance. We had a kid who played the scratch-off lottery and he won $10,000. And so the issue is, what are we going to do with it? So I said, if you haven't funded the ABLE account this year, $10,000 can go into that account and then he can keep his benefits. So we need to report that he got $10,000, but here's a receipt showing it went to the ABLE account. Again, if there's a small inheritance, grandma left $2,500 outright to a beneficiary, then we would want that money to be put into the ABLE account. Again, if you haven't fully funded it or it hasn't been fully funded for that year. Part of the reason I say don't just start putting money in it. If you want to save money for your beneficiary, that should go into a third-party special needs trust. No payback requirements, no limitations on the use of the funds, as long as they're for the benefit of the beneficiary. And so if you want to fund it, the ABLE account would not be where I would suggest you put the funds. But these are other ways to save the money. So if there's a UTMA account, a Uniform Transfers to Minors Act account, prior to age 21, that's not a counted resource, but post age 21, it is that beneficiary's money. So if you move it over before they turn 21, then you don't have to worry about it afterwards becoming a countable resource. Excess wages for Social Security or their employment, you aren't going to have the money go directly into the ABLE account. It's still income to the beneficiary, but the money could go into their personal account. They're going to pay whatever expenses they have, room or board or whatever. But if towards the end of the month you see that that account is starting to creep up towards the $2,000 limit, then you could put the excess money into that ABLE account. They can use it as a savings account. That's its whole purpose, was to allow folks who otherwise can't have more than $2,000 to have a way to save money. I mean, we want them to be fiscally responsible when they can. We want them to understand it's hard to get money, and having some kind of an emergency fund for beneficiaries is really, really important. And again, you can get a debit card, at least with the Arizona program. That's not true of all of the programs. And the money can be used out of the ABLE account for food and shelter to avoid that income offset. Let me see what a question is here. So for a low-income family with a 19-year-old disabled child who's getting SSI and working part-time, then the issue is, in order to stay below the $2,000 limit, really the ABLE account is the place to put it, because if the money goes into, if the money is given to the parents, that's a transfer and would affect Social Security as well as All-Tex and DDD benefits. If the child is living with you, the adult child, you can certainly do a rent agreement with them, or they can pay their proportionate share of the household expenses. So if there's 3 of you living in the house, then he can pay for 1/3 of whatever the costs are that he can afford, of course. But we can't, if the money's in the ABLE account, it's not going to go back to the family at death if the person is on Medicaid. Now, if they're only on SSI, there's no repayment for SSI either out of a special needs trust or out of an ABLE account. But oftentimes, and in Arizona, and I've had this discussion with our recovery agents, they have not recovered when they're just on access health insurance. The recovery is for beneficiaries who are on the long-term care piece. So if they're on Altex or DDD funded by Altex and they're receiving services. So if they're not on DDD getting services, you might not have to worry about the payback. But otherwise, I would have that child pay as much of the expenses as they can pay on their own, and you might not need an account for the extra $2,000. You know, they can pay for their own clothes and other things like that. Otherwise, you do risk the payback and those funds not coming back to the family. So you can have all of these various things, and I'm almost out of time, but you might have a beneficiary who has an ABLE account because they have money that needed to go there that was their own. You might have a first-party special needs trust because the amount that they received was more than could go into the ABLE account. And you might have a third-party special needs trust because in your own estate planning, you've set up a way where they could receive an inheritance, but not directly to them, that would go into the trust for the benefit of that beneficiary without the payback requirement. So we do see that people have all of these things, and sometimes they have different third-party special needs trusts. They have divorced parents, and each of the parents has set up a third-party special needs trust. So when that parent dies, the money would go into the third-party special needs trust, but they don't want their ex-spouse to be the one who's going to manage those monies. The other way we use first-party special needs trust, which I should have mentioned, for a beneficiary who's going to get SSI for a divorced couple, is to have the court assign the child support irrevocably into a first-party special needs trust, so it doesn't count as income to the beneficiary, and then they should still get their full SSI instead of an offset because they're also getting child support, which post age 18 is deemed to be income to the child. So I know that's a lot of technical terminology, but if you're divorced and your disabled adult child is still getting child support, but their SSI was reduced, you probably want to talk to an attorney about a way maybe to get the maximum SSI and keep the child support payments. So all of these, the purpose is to allow those beneficiaries to continue to get SSI, DDD, and Altex benefits and still have kind of a pot of extra money. But remember, all of this needs to be reported to any agencies that provide services to your beneficiary. Don't hide it. It will just be a disaster later. So in summary, you want to make sure that that third-party special needs trust is part of your estate plan. It better not have any language in it that says there's a payback to the state of any Medicaid agency, because there should not be in those trusts. First-party special needs trusts are created with money from that beneficiary, personal injury, probate matter where they received an outright distribution, wherever those funds came from. And on the death of the beneficiary, the Medicaid agencies that provided services to that beneficiary would be the primary beneficiary. Any money left over can go to other people. ABLE account, anybody can add money to it, has the same payback requirement as the first party special needs trust after we pay for some administrative expenses and funerals. And that one has a limit on how much can go into it on an annual basis. So I hope this was helpful. I really appreciate that you guys hung with me. I know it can be pretty intense and dense information. I hope you are all doing well and that you'll join us next month for our next webinar. And we are currently working on our calendar for next year. So if you have ideas of topics or people you've heard speak that you would really like to hear again, just shoot us an email. It's been my pleasure. Someday I hope to see you all again in person. So stay well, and we'll talk to you soon. Thank you.